Mark Furman from Tarlow, Breed, Hart and Rogers with Entrepreneurship and the Law. Welcome back, Mark.
Great to be here, Jeffrey. Season's greetings. I want to talk about something that's been of concern for me. I've talked about it before, but it's such a problem for entrepreneurs and business owners in this state. I just keep going back to it, and that is the anomaly that we have in Massachusetts about the independent contractor versus employee rules. It's a trap for the unwary. There's not enough publicity about it, and too many entrepreneurs are running their business creating a substantial legal risk. So for 70, 80 years, we had a rule that basically focused on whether employers control the person providing the services. We used that approach for tax purposes with the IRS, for state tax purposes with the Department of Revenue. We used it for Social Security purposes. We used it for labor relations purposes in the National Labor Relations Board and the Fair Labor Standards Act. And it was the law in Massachusetts. And then, on July 1904, our legislature, in their wisdom, changed the law, which made Massachusetts different than 49 other states, made Massachusetts different than the federal rule, and the amount of publicity over the last 9 years about this dramatic change in the law is almost non-existent. And since this change, industry by industry has had to defend class action lawsuits brought on behalf of folks who were treated as independent contractors, claiming that they were really employees as a result of this 2004 invention of our legislature. So the rule before '04 was if you could have an independent contractor, if the person providing services was free from the control of the company, if such services were either outside the usual course of business of the company or is performed outside of the business of the company. So take the example of a lawyer who has his own office, who I asked to assist me on a case because he handled an identical case, or she handled an identical case 3 years ago, and I thought it would be cost effective to the client. Under the old rule, that person was not my employee. That person had his or her own office, his or her own staff, legal assistants, law clerks, computer system, billing system, office, etc. And then